Hello, friends. Welcome to Premier UPSC IAS. Today, with continuing with the polity topic, today we are continuing with the topic of Parliament, that is Union Legislature. Role of Parliament. The Parliament is the legislative organ of the Union government. It occupies a preeminent and central position in the Indian democratic political system due to adoption of the parliamentary form of government, also known as Westminster model of government. It enjoys extensive powers and performs a variety of functions towards the fulfillment of its constitutionally expected role. Power and the functions of the Parliament. Legislative powers and functions, executive powers, financial powers, constituent powers, judicial powers, electoral powers, and other powers and functions. Legislative powers and functions. Parliament's primary function is to make laws for the governance of the country. It has exclusive power to make laws on the subjects enumerated in the Union list and on the residuary subjects, that is, subjects not enumerated in any of the three lists. Those are residuary. With regard to concurrent lists, the Parliament has overriding powers, that is, the law of the Parliament prevails over the law of the state legislature in case of a conflict between the two. The Constitution also empowers the Parliament to make laws on the subjects enumerated in the state list under the following five abnormal circumstances. 1. When Rajya Sabha passes a resolution to that effect. When a proclamation of national emergency is in operation. 3. When two or more states make a joint request to the Parliament. When necessary to give effect to the international treaties, agreements, and conventions. When President rule is in operation in the state. All the ordinances issued by the President during the recess of the Parliament must be approved by the Parliament within 6 weeks after its reassembly. The Parliament makes laws in a skeleton form and authorizes the executive to make detailed rules and regulations within the framework of the parent law. This is known as delegated legislation or executive legislation or subordinate legislation. Parliament examines such rules and regulations placed before it. Executive powers and functions. The Constitution of India established a parliamentary form of government in which the executive is responsible to the parliament for its policies and acts. Hence, the parliament exercises control over the executive through question hour, 0 hour, half an hour discussion, short duration discussion, calling attention motion, adjournment motion, no confidence motion, censure motion, and other discussions. It keeps a vigil on the activities of the executive with the help of its committees, like Committee on Government Assurance, Committee on Subordinate Legislation, Committee on Petitions, etc. Collective responsibility of the ministers to the lower house of the parliament. Also, each minister is individually responsible for the efficient administration of the ministry under his charge. This means that they continue in office so long as they enjoy the confidence of the majority members in the Lok Sabha. In other words, the Council of Ministers can be removed from the office by the Lok Sabha by passing a no confidence motion. The Lok Sabha has the following ways to also express the lack of confidence in the government. 1. By not passing a motion of thanks on the President's inaugural address. 2. By rejecting a money bill. 3. By passing a censure motion or an adjournment motion. 4. By defeating the government on an issue which is vital. 5. By passing a cut motion. Therefore, the first function of the Parliament can be said to be to select the group which is to form the government, support and sustain it in power so long as it enjoys its confidence, and to expel it when it ceases to do so, and leave it to the people to decide at the next general election. Financial powers and functions. Without the authorization and approval by the Parliament, no tax can be levied or collected, and no expenditure can be incurred by the executive. Hence, the budget is placed before the Parliament for its approval. The enactment of the budget by the Parliament legalizes the receipts and expenditure of the government for the ensuing financial year. Parliament also scrutinizes government financial performance and spending with the help of its financial committees. These include Public Accounts Committee, Estimates Committee, and Committee on Public Undertakings. They shed light on the cases of illegal, irregular, unauthorized, improper usage and wastage and extravagance in public expenditure. Therefore, the parliamentary control over the executive in financial matters operates in two stages. One, budgetary control. Two, post-budgetary control. Budgetary control before the appropriation of grants through the enactment of the budget. And two, post-budgetary control after the appropriation of grants through the three financial committees. The budget is based on the principle of annuality. That is, the parliament grants money to the government for one financial year. If the granted money is not spent by the end of the financial year, then the balance expires and returns to the Consolidated Fund of India. This practice is widely referred to as rule of lapse. Constitutional powers and functions. The Parliament has the powers to amend the Constitution. It can add, vary, or repeal of any provision. The Parliament can amend the Constitution in the following three ways: by simple majority, by special majority, and by special majority but with the consent of half of the all the state legislatures. However, the power to initiate the process of the amendment of the Constitution in all the three cases lies exclusively in the hands of the Parliament and not the state legislature. There is only one exception, that is, the state legislature can pass a resolution requesting the Parliament for the creation or abolition of the Legislative Council in the state. Based on the resolution passed by the state legislature, the Parliament makes an act for amending the Constitution to that effect. The constituent power of the Parliament is not unlimited. It is subject to the basic structure of the Constitution. Example, as we have seen in the Kesavananda Bharati case 1973 and Minerva Mills case of 1980. Judicial powers and functions. It can impeach the president for the violation of the constitution. It has the power to remove the vice president from his office. It can recommend for the removal of judges, including Chief Justice of the Supreme Court and the High Courts, Chief Election Commissioner, Controller, and Auditor General of the to the president. It can punish its members or outsiders for its contempt or the breach of its privileges. Electoral powers and functions. The members of the parliament participates in the election of the president along with the state legislative assemblies and the vice president. The House of People Lok Sabha elects its speaker and deputy speaker while the Council of States Rajya Sabha elects its deputy chairman. The parliament is also authorized to make laws to regulate the elections to the offices of president and vice president to both the houses of Parliament and to both the Houses of State Legislature. Representation of the People Act 1950 and 1951, the Presidential and the Vice Presidential Election Act 1952. Other powers and functions. It serves as the highest deliberative body in the country. Its approval is needed for all the three types of emergencies, national, state, and financial, proclaimed by the President. It can create or abolish the state legislative councils on the recommendation of the concerned state legislative assemblies. It can alter the boundaries, increase or decrease the area, and change the names of states of the Indian Union. It can regulate the organization and jurisdiction of the Supreme Court and High Courts and can establish a common High Court. Position of the Rajya Sabha. The constitutional position of Rajya Sabha as compared with the Lok Sabha can be studied from three angles. where Rajya Sabha is equal to Lok Sabha, where Rajya Sabha is unequal to Lok Sabha, where Rajya Sabha has special powers that are not at all shared with the Lok Sabha. Equal status with Lok Sabha. Introduction and passage of ordinary bills, introduction and passage of constitutional amendment bills, introduction and passage of financial bills involving expenditure from the Consolidated Fund of India, election and impeachment of the President, election and removal of the Vice President. However, Rajya Sabha alone can initiate the removal of Vice President, but not the Lok Sabha. He is removed by a resolution passed by the Rajya Sabha by a special majority and agreed to by the Lok Sabha by a simple majority, making recommendation to the President for the removal of Chief Justice and judges of Supreme Court and High Courts, Chief Election Commissioner and Comptroller and Auditor General, approval of ordinances issued by the President, approval of proclamation of all three types of emergencies by the President, selection of ministers including the Prime Minister. Under the Constitution, the ministers including the Prime Minister can be members of either house. However, irrespective of their membership, they are responsible only to the Lok Sabha. Consideration of the reports of the constitutional bodies like Finance Commission, Union Public Service Commission, Comptroller and Auditor General, etc. Enlargement of the jurisdiction of the Supreme Court and the Union Public Service Commission. Unequal status with Lok Sabha. A money bill can be introduced only in the Lok Sabha and not in the Rajya Sabha, whereas financial bill can be introduced in Rajya Sabha also. Rajya Sabha cannot amend or reject a money bill and should be returned to the Lok Sabha within 14 days, either with recommendations or without recommendations. The Lok Sabha can either accept or reject all or any of the recommendations of the Rajya Sabha. In both the cases, the money bill is deemed to have been passed by the two houses. A financial bill not containing solely the matters of Article 110 also can be introduced only in the Lok Sabha and not in the Rajya Sabha. With regard to the passage of financial bills, both the houses have equal powers. The final power to decide whether a particular bill is a money bill or not is vested in the Speaker of the Lok Sabha. The Speaker of Lok Sabha presides over the joint sitting of both the houses. The Lok Sabha with greater number wins the battle in a joint sitting, except when the combined strength of the ruling party in both the houses is less than that of the opposition parties. Rajya Sabha can only discuss the budget but cannot vote on the demands for grants, which is the exclusive privilege of the Lok Sabha. A resolution for the discontinuance of the national emergency can be passed only by the Lok Sabha and not by the Rajya Sabha. The Rajya Sabha cannot remove the Council of Ministers by passing a no confidence motion. This is because the Council of Ministers is collectively responsible only to the Lok Sabha. But the Rajya Sabha can discuss and criticize the policies and activities of the government. Special power of Rajya Sabha. As per Article 249, it can authorize the Parliament to make a law on a subject enumerated in the state list. As per Article 312, it can authorize the Parliament to create new All India services common to both the centre and states. Removal of Vice President from his post. Rajya Sabha alone can initiate the removal of the Vice President. He is removed by a resolution passed by the Rajya Sabha by a special majority and agreed to by the Lok Sabha by a simple majority. Utility of Rajya Sabha. Even though the Rajya Sabha has been given less powers as compared with the Lok Sabha, its utility is supported on the following grounds. It checks hasty, defective, careless, and ill considered legislation made by the Lok Sabha by making provision of revision and thought. It facilitates giving representation to eminent professionals and experts who cannot face the direct election. The President nominates 12 such persons to the Rajya Sabha. It maintains the federal equilibrium by protecting the interests of the states against the undue interference of the center. Central Council of Ministers, real executive authority. Article 74, Council of Ministers to aid and advise President. Article 75, other provisions as to ministers. 77, conduct of business of the Government of India. 78, duties of Prime Minister as respects the furnishing of information to the President, etc. 88. Rights of Ministers and Auditor General of India as respects the Houses. Council of Ministers, Article 74. There shall be a Council of Ministers with the Prime Minister at the head. Its size and classification are, however, not mentioned in the Constitution. It aims to aid and advise the President, who shall, in the exercise of his functions, act in accordance with such advice. However, the President may require the Council of Ministers to reconsider such advice, and the President shall act in accordance with the advice tendered after such reconsideration. The advice tendered by ministers to the President shall not be inquired into any court. Composition of the Council of Ministers. Prime Minister, the supreme governing authority of the country, at the top of all these ministers. 1. Cabinet ministers. 2. Ministers of states. And 3. Deputy ministers. Head the important ministries, cabinet ministers, members of the cabinet, important role in deciding the policies. Ministers of states either be given independent charge of ministries or departments or can be attached to cabinet ministers not members of the cabinet. Deputy ministers not given independent charge of ministries or departments attached to the cabinet ministers or ministers of states not members of the cabinet. Role of ministers of states. 1. Independent charge of ministry or department attached to the cabinet ministers. Article 75. Appointment of ministers. The Prime Minister shall be appointed by the President. The other ministers shall be appointed by the President on the advice of the Prime Minister. This means that the President can appoint only those persons as ministers who are recommended by the Prime Minister. A member of either House of Parliament belonging to any political party who is disqualified on the ground of defection shall also be disqualified to be appointed as a minister. This provision was added by 91st Amendment Act of 2003. Appointment of a person who is not a member of parliament. Usually, the members of parliament, either Lok Sabha or Rajya Sabha, are appointed as ministers. A person who is not a member of either house of parliament can also be appointed as a minister, but within 6 months, he must become a member of either house of parliament, otherwise, he ceases to be a minister. He may become a member either by election or by nomination. Strength of the Council. The total number of ministers, including the Prime Minister, in the Council of Ministers shall not exceed 15% of the total strength of the Lok Sabha. This provision was added by the 91st Amendment Act of 2003. Term of Ministers. The ministers shall hold office during the pleasure of the President. A minister who is not a member of the Parliament, either House, for any period of 6 consecutive months shall cease to be a minister. Salary, oath, and responsibility. The salaries and allowances of ministers shall be determined by the Parliament. The President shall administer the oaths of office and secrecy to a minister. The Council of Ministers shall be collectively responsible to the Lok Sabha. Oath of the Ministers. Before a minister enters upon his office, the President administers to him the oaths of office and secrecy. In his oath of office, the minister swears to bear true faith and allegiance to the Constitution of India, to uphold the sovereignty and integrity of India, to faithfully and conscientiously discharge the duties of his office, and to do right to all manner of people in accordance with the Constitution and the law without fear or favor. So, to do right to all manner of people in accordance with the Constitution and the law without fear or favor, affection or ill will. In his oath of secrecy, the minister swears that he will not directly or indirectly communicate or reveal to any persons any matter that is brought under his consideration or becomes known to him as a union minister, except as may be required for the due discharge of his duties as such minister. Collective responsibility of ministers. Article 75 clearly states that the Council of Ministers is collectively responsible to the Lok Sabha. This means that all the ministers own joint responsibility to the Lok Sabha for all their acts of omission and commission. When the Lok Sabha passes a no confidence motion against the Council of Ministers, all the ministers have to resign, including those ministers who are from the Rajya Sabha. The president may not oblige the Council of Ministers that has lost the confidence of the Lok Sabha. Alternatively, the Council of Ministers can advise the President to dissolve the Lok Sabha on the ground that the House does not represent the views of the electorate faithfully and call for fresh elections. The principle of collective responsibility also means that the cabinet decisions bind all cabinet ministers and other ministers, even if they differed in the cabinet meeting. It is the duty of every minister to stand by cabinet decisions and support them, both within and outside the parliament. If any minister disagrees with a cabinet decision and is not prepared to defend it, he must resign. Individual responsibility of ministers. Article 75 states that the ministers hold office during the pleasure of the president. This means that the president can remove a minister even at a time when the Council of Ministers enjoys the confidence of the Lok Sabha. However, he removes a minister only on the advice of the PM. In case of difference of opinion or the dissatisfaction with the performance of a minister, the Prime Minister can ask him to resign or advise the President to dismiss him. No legal responsibility of ministers. Unlike the British Parliament, in Indian parliamentary system, there is no provision in the constitution for the system of legal responsibility of a minister. It is not required that an order of the president for a public act should be countersigned by a minister. Moreover, the courts are barred from inquiring into the nature of advice rendered by the ministers to the president. Conduct of business of Government of India. According to Article 77, all executive action of the Government of India shall be expressed to be taken in the name of the President. Orders and other instruments made and executed in the name of the President shall be authenticated in such a manner as may be specified in rules to be made by the President. Further, the validity of an order is or instrument which is so authenticated shall not be called in question on the ground that it is not an order or instrument made or executed by the President. The President shall make rules for the more convenient transaction of the business of the Government of India and for the allocation among the ministers of the said business. Rights of ministers as respect to the House. According to Article 88, every minister shall have the right to speak and take part in the proceedings of either House, any joint sitting of the Houses, and any committee of Parliament of which he may be named a member. But he shall not be entitled to vote in the House of which he is not a member. Prime Minister, real executive head of the Union government. Appointment and selection of the PM. The Constitution does not contain any specific procedure for the selection and appointment of the Prime Minister. Article 75 says only that Prime Minister shall be appointed by the President. However, this does not imply that the President is free to appoint anyone as a Prime Minister. In accordance with the conventions of the parliamentary system of government, the President has to appoint the leader of the majority party in the Lok Sabha as the Prime Minister. In case of no clear majority, when no party has a clear majority in the Lok Sabha, then the President may exercise his personal discretion in the selection and appointment of the Prime Minister. In such a situation, the President usually appoints the leader of the largest party or coalition in the Lok Sabha as the Prime Minister and asks him to seek a vote of confidence in the House within a month. In case of death of the incumbent PM in office, when the Prime Minister in office dies suddenly and there is no obvious successor, the President may have to exercise his individual judgment in the selection and appointment of the Prime Minister. However, if on the death of an incumbent Prime Minister, the ruling party elects a new leader, the President has no choice but to appoint him as Prime Minister. He may be appointed as the Prime Minister first and later asked to prove his majority in the Lok Sabha within a reasonable period of time as per the judgment of Delhi High Court given in 1980. In 1997, the Supreme Court held that a person who is not a member of either House of Parliament can be appointed as Prime Minister for 6 months, within which he should become a member of either House of Parliament. Otherwise, he ceases to be the Prime Minister. Constitutionally, the Prime Minister may be a member of any of the two houses of Parliament. Oath, term and salary of PM. The form of oath of office and secrecy for the Prime Minister is similar to that for any Union Minister. The term of the Prime Minister is not fixed and he holds office during the pleasure of the President. So long as the Prime Minister enjoys the majority support in Lok Sabha, he cannot be dismissed by the President. However, if he loses the confidence of the Lok Sabha, he must resign or the President can dismiss him. The salary and allowances of the Prime Minister are similar to a member of the Parliament and determined by the Parliament from time to time. Duty of Prime Minister. Article 78 states the following duty of the Prime Minister to communicate to the President all decisions of the Council of Ministers relating to the administration of the affairs of the Union and proposals for legislation, to furnish such information relating to the administration of the affairs of the Union and proposals for legislation as the President may call for, and if the President so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by a minister but which has not been considered by the Council. Power and the functions of the Prime Minister in relation to Council of Ministers, in relation to the President, in relation to Parliament, other powers and functions. In relation to the Council of Ministers, he recommends persons who can be appointed as ministers by the President. He allocates and reshuffles various portfolios among the ministers. He can ask a minister to resign or advise the President to dismiss him in case of difference of opinion. He presides over the meeting of Council of Ministers and influences its decisions. He guides, directs, controls, and coordinates the activities of all the ministers. He can bring about the collapse of the Council of Ministers by resigning from office. In relation to the President, he is the principal channel of communication between the President and Council of Ministers. He advises the President with regard to the appointment of the following important officials like Attorney General of India, Comptroller and Auditor General of India, Chairman and members of the UPSC, Election Commissioners, Chairman and members of the Finance Commission, and so on. In relation to the Parliament, the Prime Minister is the leader of the lower house. In this capacity, he enjoys the following powers. He advises the President with regard to summoning and proroguing of the sessions of the Parliament. He can recommend dissolution of the Lok Sabha to President at any time. He announces government policies on the floor of the House. Other powers and functions. He is the ex officio chairman of the following Niti Aayog, National Integration Council, Interstate Council, and National Water Resources Council. He plays a significant role in shaping the foreign policy of the country. He is the chief spokesman of the union government. He is the crisis manager in chief at the political level during emergencies and so on. Attorney General of India, AGI, highest law officer in the country. Article 76, Attorney General of India. Article 88, Rights of the Attorney General as respects the Houses of Parliament and its committee. 105, Powers, privileges and immunities of the Attorney General. Qualification. He must be a person who is qualified to be appointed a judge of the Supreme Court. In other words, in the opinion of the President, he must be a citizen of India and he must have been a judge of some high court for 5 years or an advocate of some high court for 10 years or an eminent jurist. Appointment and term. The Attorney General of India is appointed by the President. The term of office of the Attorney General is not fixed by the Constitution. Further, the Constitution does not contain the procedure and ground for his removal, meaning that he may be removed by the President at any time. He may also quit his office by submitting his resignation to the President. Conventionally, he resigns when the government, Council of Ministers, resigns or is replaced as he is appointed on its advice. Duties and functions. As the Chief Law Officer of the Government of India, the duties of the Attorney General include the following: to give advice to the Government of India upon such legal matters which are referred to him by the President, to perform such other duties of a legal character that are assigned to him by the President, to discharge the functions conferred on him by the Constitution or any other law. The President has assigned the following duties to the Auditor General: to appear on behalf of the Government of India in all cases in the Supreme Court in which the Government of India is concerned, to represent the Government of India in any reference made by the President to the Supreme Court under Article 143 of the Constitution, to appear when required by the Government of India in any High Court in any case in which the Government of India is concerned. Rights and limitations. In the performance of his official duties, the Attorney General has the right of audience in all courts in the territory of India. Also, he enjoys certain special privileges, right to speak and to take part in the proceedings of both the Houses of Parliament or their joint sitting, can be the member of any committee of the Parliament of which he may be named a member, but without a right to vote, all the privileges and immunities that are available to a member of Parliament. Following are the set of limitations placed on the Attorney General in order to avoid any complication and conflict of duty. He should not advise or hold a brief against the Government of India in cases in which he is called upon to advise or appear for the Government of India. Without the permission of the Government of India, he should not defend any accused persons in criminal prosecutions, accept any appointment as a director in any corporation or company. However, the Attorney General is not a full-time counsel for the government. The Attorney General is also not a member of the Central Cabinet. There is a separate law minister in the Central Cabinet to look after legal matters at the government level. Since he does not fall in the category of government servants, further he is not debarred from private legal practice. He reserves such remuneration as the President may determine. Solicitor General of India. In addition to the Auditor General, in addition to the Attorney General, there are other law officers of the Government of India. They are the Solicitor General of India and the Additional Solicitor General of India. Solicitor General of India and the Additional Solicitor of General of India assist the Attorney General in the fulfillment of his official responsibilities. Article 76 mentions only about the office of the Attorney General and does not mention about the office of Solicitor General and Additional Solicitor General. State Council of Ministers. 163. Council of Ministers to aid and advise Governor. Article 164. Other provisions as to ministers. Article 166. Conduct of business of the government of a state. Article 167. Duties of Chief Minister as respects the furnishing of information to Governor, etc. Article 177. Rights of ministers as respects the houses. Cabinet committees. Super cabinet. Features of cabinet committees. They are not mentioned in the constitution, therefore are regarded as extra constitutional. Since the rules of business provide for their establishment, they are of two types, standing and ad hoc. The standing committees are of a permanent nature, while the ad hoc committees are of a temporary nature and are constituted from time to time to deal with special problems. They are dissolved or disbanded once their task is or are completed. Prime Minister constitutes them according to the exigencies of the time and requirements of the situation. Hence, their number, composition, and nomenclature varies from time to time. Usually, there are 3 to 8 member and includes only the cabinet ministers. However, the non-cabinet ministers are not absolutely excluded from their membership. They not only include the ministers in charge of the respective portfolio, but also include other senior ministers. They are usually headed by the PM. Sometimes other senior cabinet ministers, especially the Home Minister or the Finance Minister, also acts as their chairman. But if the Prime Minister is a member of a particular committee, he invariably presides over it. They also take decisions apart from sorting out issues and formulate proposals for the consideration of the cabinet. However, the cabinet has the authority to review their decisions. They are an organizational device constituted in order to reduce the enormous workload of the cabinet. They also facilitate effective coordination and in-depth examination of policy issues. They are based on the principles of effective delegation and division of labor. Functions of the cabinet committees. Political Affairs Committee, chaired by the PM, it deals with all policy matters pertaining to domestic and foreign affairs. Economic Affairs Committee, chaired by the PM, it directs and coordinates the governmental activities in the economic sphere. Appointments Committee, chaired by the PM, it decides all higher level appointments in the public enterprises, central secretariat, banks, and financial institutions. Parliamentary Affairs Committee, chaired by the Home Minister, It looks after the progress of government business in the parliaments. Political Affairs Committee is the most powerful among all the cabinet committees and is often described as super cabinet political affairs committee.